Call our third case, 128108 out of Douglas County, First Presbyterian Church versus City of Lawrence and Fountain Residential Partners. If council could please announce their appearances.
Richard, may I please the court, Richard W. Hurd on behalf of the plaintiff, First Presbyterian Church.
And would you like rebuttal time, Mr. Hurd?
Yes, I would like to reserve 5 minutes for rebuttal.
5 minutes is granted.
Randall F. Larkin, Deputy City Attorney, appearing, and Zachary T. Friedel, who's an Assistant City Attorney, appearing in behalf of defendant, appellee, cross appellant, City of Lawrence, Kansas.
And no appearance by Fountain. Oh, sorry.
Your Honor, Greg Musil on behalf of Fountain Residential, who's also represented by Trevor Tollett in the audience.
And will you both be arguing?
Yes, we will take 10 minutes and the intervener will take 5 minutes.
Alrighty. All right, Mr. Hurd, you may proceed.
Thank you, Your Honor. This is a land use case involving interpretation of an ordinance of the City of Lawrence, Kansas, defining what is a duplex. This is the second time this case has been on appeal. Just to give you a little bit of background, the church is located on Clinton Parkway in Lawrence, where it's across the street from a vacant 9.1 acre tract, which is Fountain is the contract purchaser of that 9.1 acre tract.
So why is the church concerned with what's going to happen to a tract that is not owned?
Well, for 2 reasons. One is what is being proposed is an incredibly dense development in an area where it doesn't belong. And to give you a little bit of background on that, in 2018, the owner of the property tried to get it rezoned for multifamily development. That was opposed by not only the church, but others, and it was defeated. So the tract sat empty, and then the owner came back with this developer and decided, well, if we can't do multifamily, get a zoning change for multifamily, what we're going to do is we're going to make that 9 acres into one lot and put 57 duplexes and 6 detached dwellings on it. It'll have a rental office. It'll have a swimming pool. It'll look every bit like multifamily residential development, but we're going to call it duplexes. And because the code, according to the city and the developer, because the code doesn't restrict the number of duplexes on one lot, we'll just make it a 9.1 acre single lot. And that's what brought the church into this, is the opposition to that interpretation of the definition of duplex. This is simply an end run around what was defeated previously. And that's what caused the church to get involved.
Council, I know you want to start defining duplex, but I have a question, and you talked about density, and I'd like to focus on that if you don't mind. In City Code 20-203A, it provides that the primary purpose of a RSO district is to accommodate low to medium intensity. How is low to medium intensity defined? Because isn't that the parameters that must work with the property across from the church?
I would answer that in a couple of ways. First of all, I don't know that that is defined as to what is low to medium density. If it is, I couldn't stand here and cite you to it, okay? My memory isn't that good. But what I will tell you is this. There is a density requirement set out in, I think, Article 6, and that's what the district court focused on. The district court said there are uses in Article 2, there's density limitations in Article 6. But the definitions of various types of housing limit by themselves the number of structures or uses that can be put on a single lot. And for example, attached dwellings, or townhomes as we would call them, must be on their own lot. But townhomes, just like duplexes, are also subject to the density limitations in Article 6. They are consistent. There's nothing offended by the density requirements in Article 6 by what we are suggesting is a requirement for a duplex to be on its own lot. They simply need to draw lot lines around the duplexes. What the developer has determined is they can't get as many on that lot if they do that because of the setback requirements. It would also suggest that 57 duplexes and 6 detached dwellings on a 9-acre parcel, while it may meet barely the density limitations in Article 6, is not low density. It's a multifamily housing development where it doesn't belong.
Is there a difference between intensity and density? I just want to make sure. I don't want to make any assumptions.
Again, I'm not sure I could cite you the code, but I think intensity refers to uses such as on the low end, you have single family residential. On the high end, you have industrial uses. The intensity follows the, I'm going to define it by saying intense. More commercial uses would be more intense.
Okay.
Residential would be less intense.
And that's why under the code, it says has to be compatible with the character of low and medium density residential neighborhoods.
Correct. And what we're suggesting is that by defining it in the manner that the church is suggesting, that it fits with the lower density, maybe even medium density, but we're suggesting that it needs to be treated very much like single family residences in that they're on their each building containing a 2 living units is on a separate lot. It's on one lot, okay? I think what the court struggled with a little bit and was discussed in the previous appeal is the use of the word single in the definition. A duplex is a single structure with 2 living units on one lot. If the definition said a structure with 2 living units on one lot, that might strengthen the city's position. But the use of the word single is important here. And the evidence that we provided at trial showing where the definition of duplex originated in the drafts of this new code, I think is incredibly important to understand because that's the only evidence. In this proceeding, the city provided 0 evidence of legislative history or legislative intent. They claimed it doesn't exist. The developer took the same tack. There is no evidence of legislative history or legislative intent. We provided evidence at the district court level of the prior drafts of the ordinance. The drafts were prepared by a company called Duncan Associates in Chicago, hired by the city to rewrite the code. And it was the first rewrite of the code since 1966.
But that's not really, I mean, drafts is not really legislative history. I mean, it's not as though those were submitted to the governing body and they molded over and had meetings and what testimony and what have you as we would contemplate legislative history. I mean, these were just proposals more so, really, correct?
Well, Your Honor, I think the case law indicates that prior drafts, committee reports, things that were done in the legislative process is legislative history.
But doesn't that contemplate that the drafts had discussion, not just that they were written and submitted as they were in this case?
I think it would help if they had been discussed, but I think it was that's up here.
Well, I have a curious question.
Yes.
If the church objects to the development of this lot, why don't the church just buy it and develop it themselves however they want in accordance with city ordinance?
Well, that would require the city to purchase the real estate, Your Honor.
Well, it would require the church to buy it.
Correct. I don't think there's any requirement that the church buy it. I mean,
No, I'm not saying, but the church is trying to control how a developer is allowed to utilize their land that has been approved by the city council. Is that correct?
the church is trying to prevent the developer from constructing a development that is contrary to the city code, regardless of what the planning director said.
But the district court disagreed with you.
Yes.
Okay,
The district court, yes, the district court did disagree with me ultimately, yes.
we go back to my last question. If the church wants to control how this tract is developed next to its property, why didn't the church just buy the tract undeveloped?
Well, I have no idea if the church has the wherewithal to do that, but it's certainly their right to require development in the city to be in accordance with law. They shouldn't have to make a financial investment to purchase property and control it just to ensure that development is done legally.
Ms. Stogsdill testimony,
Yes,
most of it was objected to
yes,
and sustained by the district court. But there was one statement that she made. The RSO was intended to be a lower density buffer district between small family and higher intensity uses.
yes.
So is that considered legislative history? What label do I put on that statement she made?
Well, I think it's legislative history in that, and it might be legislative intent in that it shows what this was designed for. Ms. Stogsdill was wanting to testify not only about the reasons for the changes in the code and why these changes were made, but I also asked her questions about her conversations with Duncan Associates before the adoption. Now, I understand the district court relied on the Davis case heavily in sustaining the objections to her testimony. But the Davis case does not say that pre-enactment statements are not admissible. And that's what she was asked about. What was your discussion with Duncan prior to the adoption? Give us some background on how this evolved, okay? And that was cut off by the district court, and that is, we think, is clear error.
But isn't the whole point of legislative history, the reason why courts look at it is because it is verifiable? We can pull the Senate notes and we can quote the changes of the statute. So there's a fundamental reliability, which is why if a statute's ambiguous, we look at canons of construction, reliable. We also look at legislative history. Here, aren't we dealing with something outside of that?
And I would answer it with no. And the reason is this. Ms. Stogsdill testified about the series of drafts that was prepared. Those are in black and white. They are verifiable. The question that she was not allowed to testify about is why and what they mean. In this case, it's different than the Davis case, different than Monsanto, in that Sheila Stogsdill was not a lobbyist. She was not a legislator. She was someone that had 30 years of experience with the city of Lawrence. She was the point person for this project. All communications with Duncan Associates in terms of drafts went through her. All the editing was done between her and Duncan. She was an incredibly well-qualified person to give some insight. And there is no reason given why her testimony should be distrusted in any manner. In fact, all the indicia of prejudice, i.e. being a legislator or being a lobbyist, are not present here. She is an absolute neutral. So sworn testimony under oath, I think, verifies what the drafts said. I hope that answers your question.
Yes, thank you.
You are getting into your rebuttal time. You may either go ahead or just reserve your time.
Let me mention one other thing, and I'm going to eat into my rebuttal time. The district court was supposed to look at the historical application of the code in the process of determining intent. In this case, the historical application of the code, since it was developed, consists of a very limited number of developments. There are no places in the city of Lawrence with RSO zoning where there are multiple duplexes on one lot. None. There are several developments, including one at Stonehawk Court, I think, where there were 14 duplexes in RSO zoning, each on their own lot, just as the city is contending. Every other example provided by the city and Fountain related to developments that were done pre-code, or they were done as a planned residential development, which have entirely different rules. I'm going to save the rest of my time for rebuttal. Thank you.
Thank you, Mr. Hurd.
May it please the court, counsel. This case is a KSA 12760 appeal of the zoning decision, where the plaintiff challenges the lawfulness of the defendant city's governing body's decision to affirm the administrative approval of a site plan. And in this appeal, the only issue is whether or not the city's definition of the duplex use prohibits by its very terms the location of multiple duplexes on one lot. The section that is in issue is a fragment. It defines the duplex use as a single structure that contains two primary units on one lot. That involves the interpretation of city code, which is a question of law. On appeal from that decision, the district court found that the section unambiguously did not limit the number of duplexes that could be located on one lot and dismissed the case for failure to state a claim upon which relief could be granted. On appeal to this court, without applying the rules of grammar to that fragment, the court found that it was plausible, though not probable, that as the plaintiff urges, the prepositional phrase on one lot modifies structure as opposed to the dwelling units being on one lot, and remanded it to the district court for three things to be done: to examine the legislative history of the definition, and to ascertain any historical application of the definition by the city, and then to also apply the canons of statutory construction, reading all of the parts of the city code in peri materia to ascertain what the intent of the governing body was in 2006 when it enacted this provision. That is the key to the case, what the governing body's intent was. And then I'm going to talk right now about the cross appeal. On remand, the parties engaged in discovery, and at the close of discovery, defendants moved the court for summary judgment, arguing that the uncontroverted facts of the case established that there was no legislative history, that to the extent that it could be relevant, the historical application showed that there were multiple sites within the city where multiple duplexes were located on one lot, and that in reading the code provisions in peri materia, it established that the intent of the governing body was not to limit the duplexes to one lot per duplex. In response to that motion, the plaintiffs offered nothing. They did offer some of the previous drafts, but none of those were authenticated. They were just basically future promises of evidence that would establish something, which in our opinion was not enough to overcome a motion for summary judgment. And on that basis, we would argue that the court should have granted the motion for summary judgment, erred in not doing so, and the city would ask the court to reverse the decision of the court in that basis. Nevertheless, after the denial of the motion for summary judgment, and this gets to the appeal portion, the court found basically what we asked for on summary judgment, so that may all fold into that. But over the objections of the city, it went to trial, and so they tried the facts of the case, and during discovery, as we noted before, the parties were unable to discover any legislative history. That was confirmed at the trial of this case, as no admissible legislative history was admitted into evidence or discussed by the parties, and no legislative history evincing the intent of the city's governing body was adduced at trial. Now, regarding evidence of other factors, which defendant city has consistently objected to throughout this case on the grounds that it's irrelevant, because the city may have dozens of properties on which there are multiple duplexes located in an RSO zoning district, but may have done so illegally over years, and there could be many. Or we might not have any not because it was illegal, but just because no one wanted to do it or no one tried to do it. And that was this case. But in any event, we did show there was evidence adduced at trial that showed that the city has no RSO zone properties with multiple duplexes on them. And it also showed that no one had ever tried to do this. No one had ever made an application to do so. the city never denied any application to locate multiple duplexes on an RSO lot. The only application that was ever made was this one, and it was approved. There are RSO properties within the city that contain multiple uses and multiple structures on one lot, and there are lots within the city where there are multiple duplexes located on one lot.
So do the density requirements of a RSO district assist you in this?
Yes, they're set forth in 2601, and this with 57 duplexes and 6 attached dwellings was 120, which was less than is like 13 individuals or persons per acre, and I think the limitation is 15, so they could have actually had 1.5 more persons per acre in this development. So it met the density requirements.
So density is 15, this came in at 13.
Yes, 13.5, I believe.
I was doing the math and it was like 15 times 9 acres, you get 135, but you're about 120.
Yes, absolutely. So as noted above, the inference must be that the governing body in this case did not ever intend to limit the location of multiple duplexes to each in their own lot. Now, turning now to the definition. So then we go to the canons of statutory construction, which are key in doing the canons of statutory construction and reading the code in pari materia. The provisions of the code must be read harmoniously. The governing body's intent must govern, and the code provisions must not be construed to render them futile or meaningless. And with that, we'll turn to the code. Against that, I'll turn to the language of the duplex use. Grammatically, it really provides that 2 dwelling units must be located on one lot. Defendant city contends that using the proper grammatical construction of the sentence, its main purpose is really to distinguish it from the attached dwelling use, which occurs in the same household living section, which says that each dwelling unit of an attached dwelling has to be on its own lot, whereas the duplex, the 2 dwelling units have to be on one lot. So that is basically the purpose of that definition. Consequently, by itself, it cannot be said to prohibit the location of multiple duplexes on one lot. That construction is buttressed by section 20-204A3 of the city code, which defines the RM12D district. That district permits only duplexes and attached dwellings of 2 units, and it provides only 1 principal building per lot is permitted in this district. Now, if the duplex use definition already prohibits every single duplex structure to be located on its own lot, as plaintiff presses, then that last sentence is meaningless. It's unnecessary because that's already in the definition. But if the definition of the duplex use did not, as defendant city argues, then that last sentence makes perfect sense. So you can have them, except for in the RM12DD, they each have to be on their own lot. And so on that basis, the defendant city would argue that its construction is the correct one. So then we turn to section 20-203, which defines and governs the RSO zoning district. Nothing in that section limits any structure to its own lot. Contrast that with the RS and the aforementioned RM12D district, both of which require restructures within those districts to be located on their own lots. If defendant's governing body intended for the RSO district to have only 1 structure per lot, then it would have stated that specifically in the introductory part of the RSO district. And then that conclusion is borne out by section 20-601A, which governs density. That table states that properties in the RS district are restricted to minimum lot area per structure. Thus, in RS districts, which are typically restricted to 1 detached dwelling, each structure had to be located on a lot of a certain size. In the RSO and RM district, however, density is restricted to maximum number of dwelling units per acre. If it was the intent of the governing body to limit the number of structures to dwelling units per lot in the RSO district, then it would have designated the density as minimum lot area per structure rather than minimum number of dwelling units per acre as it did in those districts. So that brings us back full circle. When the duplex use is read in pari materia with the rest of the code, it is clear that the duplex use definition did not by itself limit each duplex structure to 1 lot. Rather, it is clear that as defendant notes from the grammatical parsing of it, that the purpose of the definition is only to distinguish it from the other household dwelling uses, especially the attached dwelling unit, especially when there are two units.
Remember the question I had for your opposing counsel on KSA on the city code that I was asking him about 20-203A?
Yes.
And I said, please define low to medium intensity, and then, and this is a softball question. I've never labeled it that way. A low to medium density residential neighborhood is for RSO. By the RSO being defined of having a density of 15 units, doesn't that define what low to medium density is?
That's exactly correct, Your Honor. That's exactly correct. It was originally, I think, if you track through, going to be just low density. And at some point in time, there was some discussion, the city commission, and this was changed later. So there is actually some legislative history regarding the RSO district. And this is not in the record, but they changed it from low to medium because it was going to create too many non-conforming uses. And so they went to low to medium, and 15 persons per acre is considered medium.
It's people, not structures.
Right. It's individuals. Yes. Did I say structures per acre?
No, I think Judge Pickering made.
I did.
Oh, okay. Sorry. It is 15 persons per acre is considered medium density.
You are at 5 minutes if you wanted to share with council.
And I just want to say, and those for the reasons, the rule, and when applying the Kansas statutory construction, including reading the relevant portions of the code, it is clear that the district court did not err in granting judgment at trial. And for those reasons, we would ask the court on appeal to affirm the decision of the district court in this case.
My question has no bearing on this case. If medium is up to 15,
Yes.
that's high.
Up to 40. So RM40 is the highest multi-dwelling units we have. 40 is high, 15 is medium.
Curious. Thank you.
Yes.
I'm from a small town. We don't have these issues.
That's all right. So, thank you, Your Honor.
May it please the court, Mr. Hurd and Mr. Larkin. Greg Musil on behalf of Fountain Residential. Most of it's been said, so let me try to simplify. Lawrence needs housing. Fountain Residential found a 9-acre site that says I can have low to medium density up to 15 people per acre, and I can have duplexes. And every duplex that is intended to be built here will in fact be a single structure containing 2 dwelling units on a single lot. That's the simple part about this. I know we can get into the grammatical construction and all the canons, but every one of these duplexes will be a single structure with 2 units on 1 lot.
So are you going to replat the 9-acre tract?
Into 1 lot.
So if it's 1 lot, how does a duplex set on 1 lot? Generally, a lot is lot 1, block 2 of.
It will be lot 1, but a lot can have more than 1 structure on it. I mean, that's what we're here to talk about. And I think what Mr. Larkin pointed out, all of these sections were adopted in 2006 after a 5-year period of studying the land development code. In 2006, the city commission adopted legislatively a single structure with 2 dwelling units on 1 lot, 4 duplexes. For duplexes in the RM12 district, though, it said only 1 principal building per lot, made a distinction. In detached dwelling units, it said only 1 detached dwelling unit shall be permitted on a lot unless otherwise allowed in the code. In attached dwellings, it said a dwelling unit on its own lot. Those are adopted at the same time, demonstrating the city commission knew exactly how to say you only have 1 duplex on 1 lot. It said it in the RM12D district. It didn't say it in the RSO district. And there's only 1 definition of duplex. Ms. Dogsdale's testimony confirmed that. There's 1 definition that applies across every zoning district. And in 2018, the city approved a project on Ousdale Road, OUHSDAHL, I think, with hundreds of duplexes on 1 lot. It's not an RSO zoning district, but it doesn't matter because it is a single definition of duplex. I want to talk a little bit about Ms. Stogsdale's testimony. As you know from our brief, we believe the testimony wasn't preserved. You don't know as you sit here today. Judge Simpson didn't know when he issued his ruling. None of us know today what she would have testified to because there wasn't a proper proffer. There was never a proffer that she will say, Duncan said this, I said this, the Planning Commission heard this. I think all of that would have been objectionable and inadmissible, but it was never proffered. So in this court today, you have a problem trying to figure out how that was preserved. Mr. Hurd does not like the Davis case. It was decided the same day as the McCarthy case in 1995, where an affidavit of a person who was a lobbyist involved in drafting the Main Trafficway Act of Kansas submitted an affidavit, which the district court considered. And the Supreme Court in both cases said, no, we don't consider post-enactment statements as legislative history. They cited the U.S. Supreme Court case talking about how that is a hazardous thing on which to determine legislative history. And I would urge the court to consider the policy construction, policy issues. If anyone can come in 5 years after the case, as in the State Farm case, 35 years after the enactment, as in the Davis case, or 18 years after enactment in this case, and say, well, what was said before and what was intended before is X. Because I'm going to bring somebody in to say Y and Z. And what Judge Simpson at the district court level did correctly, I think, was allow Ms. Stogsdale to talk about what. If you have evidence of drafts, when were they dated? What did they say? What were the changes? But I'll encourage you to note the record. None of that ever reached the Planning Commission, which is the first body that considers a text amendment to the Land Development Code in Lawrence under Kansas statute. None of it ever reached the City Commission. It's interesting because in the State Farm case, the chair of the legislative subcommittee that drafted the legislation was the one who attempted to testify. And the Court of Appeals in that case, it never got to the Supreme Court, said no. Even if you're a legislator drafting it as chair of the subcommittee, you are merely one person of a body. It doesn't indicate legislative intent. And Judge Pickering, I think you got it right. Is it verifiable? I don't think we want to turn statutory interpretation into credibility tests of various witnesses who say what happened 18 years ago. Or in this case, maybe 23 years ago when the Land Development Code review process just started. We're back to where we should have been in November of 2021 when the City Commission approved this. It is 57 duplexes, single structures, 2 dwelling units on one lot, completely consistent with everything the commission did in 2006 when they said, these 3 areas, I want it on their own lot. This area, I don't include that language. If you apply the interpretation rules, I don't think you can come to any other conclusion. And there's certainly nothing in this record that suggests otherwise based on the city's historical application, the fact that it approved hundreds of duplexes on a single lot in 2018, or if you look at what the code says in the various sections. I'd be happy to answer questions, but I think you've got the feel of this case.
Thank you.
Thank you.
Thank you.
Mr. Hurd, you'll have 5 minutes.
Thank you, Your Honor. First of all, I want to clarify one thing. Mr. Larkin indicated that the drafts that were submitted to the trial court were not authenticated. I think they were admitted by stipulation as the foundation, if I recall correctly. I want to address just a couple of matters, and then I'm going to wrap it up here. First of all, Mr. Larkin talked about the density being 15 persons per acre. It's really 15 living units per acre. It's not counted in people. And I think that's significant here because the number of people involved in 15 dwelling units per acre could be considerably higher. I want to also address this, two other things. One is the RM12D zoning. If I recall correctly, what it says is that in RM12D zoning, that there could only be one principal building per lot. But there's two kinds of buildings that are allowed in RM12D, attached dwellings and duplexes. So it's not superfluous language to add that language in, because we're dealing with two different kinds of buildings in RM12D. I want to address the 2018 development at 33rd and Osdale Road in Lawrence. You can see it from the K10 bypass, and it is a development that has a lot of smaller residential structures on one obvious development. He's correct that there are dozens of duplexes on that development. It's a PRD, a planned residential development. It has different rules. That's what Sheila Stogsdill testified about at trial. To illustrate the truth of what I'm saying, consider this. There are a whole 2 or 3 rows of attached dwellings or townhomes on that site. By code, by their admission, attached dwellings have to be on their own lot, but they're not in that development because it's a PRD. It's distinguishable. The fact of the matter is, this is the first time a developer has suggested that they can put 57 duplexes on one lot. It is contrary to the history of development in Lawrence. It's contrary to the developments that have occurred since the adoption of the code. It is an aberration. It is a stretch of the definition to meet their goal. For all those reasons, the church would ask the court to do one of two things. One is find as a matter of law that the definition suggested by the church is correct, that the word single in the definition of duplex has a meaning. And if the court thinks that it is still ambiguous, to send it back to the district court and allow testimony as to the legislative history and legislative intent by Ms. Stogsdill that was not allowed previously. Those reasons we ask the court to reverse the district court, and I'll stand for questions. Thank you.
Very much.
I would clarify, Mr. Hurd was correct. It is 15 dwelling units per acre is the density measure. RM40, there's 40 dwelling units per acre. That the number does refer to dwelling units, not persons. So I apologize for that misstatement.
Thank you, counsel.
Thank you. I appreciate that.